Welcome to your favorite channel, The Law Circuit, a channel dedicated to having various discussions on the current legal topics. We are here to simplify legal issues for you and make it more accessible to the common man. You said that one of the main concerns is Section 3D. How is that a problem?
So Section 3D has a long history, the reason why it has come and the why it is there and why it is being used. So I'll tell you a little bit about it. Section 3D came in for the first time in the 2005 Act. And the reason why Section 3D has come in is to prevent frivolous products from being patented. So you must understand how the pharmaceutical business works before you can understand 3D. So not only pharmaceutical business, I think it's across the board. Every company does this. So they have a series of patents, a family of patents as you would call, or a portfolio of patents on a particular product. So let's talk about a simple thing like aspirin. So let's assume that I invented aspirin. So I invented aspirin, I get the patent on aspirin. Very fine. Then I have 20 years, but I want to extend the life for another 20 years and then another 20 years. I actually want a monopoly for 100 years. So how do I do that? So I get a patent on fluffy aspirin. Aspirin which is fluffy in nature, and then I will say that you put it in water and it will immediately dissolve and immediately cure your headache. So the patent office will look at it and they'll say, yeah, this is okay, fine, I'll grant you a patent. But it is nothing but a repeat patent of the earlier aspirin, because the earlier aspirin was also curing your headache. So the filter is to show, did you make something creative? If you made something creative, of course you deserve a patent. But if you simply improve the color, if you simply improve the texture, you shouldn't be getting patent on that. So then they will come out with a new process of making aspirin, or for example, a new polymorph of aspirin, a new version of aspirin, or a new form of aspirin. So this way, I go on getting 20 years, extension. So the Indian legislature saw this and they said that in some cases, it may be mischievous. It may not be so in all the cases, but in some cases, it might be mischievous. And that is why they brought in the filter of 3D. 3D says that if a substance is a polymorph or a salt of an existing compound or a derivative, then it is incumbent on the applicant to show therapeutic efficacy, significant therapeutic efficacy, in order to get a patent. Significant therapeutic efficacy is nothing but the curative effect. So if I bring in fluffy aspirin, so I can't just go tell the patent office that, look here, I've got fluffy aspirin, give me a patent. I must show what is the next curative effect that it has. So if it cures headache, but instantly you just take a sip and then your headache is gone, maybe that's curative. That's for the patent office to evaluate. But that's the kind of filter that we have added with 3D. In some cases, people are unable to fulfill the criteria, and therefore people start complaining and they say that, this is a bad provision, we want it out of the rule book. So that's the reason why 3D is a big problem. It's been a big controversy all the time, since the time it has come on the statute book. We have a case in India which is called Novartis versus Union of India, where the Supreme Court had the occasion to interpret this provision, and they laid down the standard that when we say efficacy in Section 3D, it is nothing but therapeutic efficacy. So that's how this provision has come in, and this provision is there, and it's a safeguard. It's a safeguard against frivolous patenting. Otherwise, like in the US and other countries, patents will never go off. You will have one patent and then you will have another and then you'll have a third one. So the Indian companies who may want to make that product will never be able to make that product. So you will have a cancer drug, which is costing say 3 lakhs or 5 lakhs. And let's say there's an Indian company who wants to make it and put it in the market. And maybe he wants to bring it at 8,000, 10,000 or some kind of a cheaper price, he'll never be able to do it because there is a patent. And therefore 3D prevents such frivolous patenting. Now, this has also been admired in some countries. There are countries like Malaysia, Bangladesh, etc., South Asian countries, and many other countries also, who are looking at 3D and saying that, yeah, this is the kind of filter that we want to have. So you have both kind of views on the table, and it is for India as a country to decide whether this is an appropriate time for us to weed out 3D, or to dilute it, or to keep it as it is.
That was all from my side, ma'am. Thank you so much for explaining such a complicated 301 report to us in such a simplistic manner. Please like, share and subscribe to our channel, The Law Circuit, as we will be repeatedly coming back with you with such latest updates. Thank you.